We're live.
Okay. We're now dealing with S89, which has to do with a forensic facility for persons in need of treatment or continued treatment. And we have draft 1.1, date 3/1/23, that I think Katie was going to go over with us for the changes.
Yes, I'm happy to go over it with you. I'm trying to log into, log into Zoom. Am I in? I'm in the wrong meeting.
Do you want me to auto invite you?
Can you?
Yeah.
That'd be great, thank you.
You get it?
Please feel free to.
Yeah.
Are you going to share it on the screen or?
I'm trying to, yeah, I'm logging into
Oh, okay.
Zoom so I can share on the screen. We're having some technical difficulties. There we go. Says I don't have screen sharing. Says the host is disabled. Oh, okay.
Gotta love technology.
I know.
We're getting there, Center Sears.
Yep.
Okay. So good morning. Katie McGlynn, Office of Legislative Counsel for the record. Last time we spoke, there was a request to put a few amendments together. So what you see before you is Amendment 1.1. This is a strike all amendment because it's easier to read, not because all of the sections have been amended. All of the changes are highlighted in yellow, so they should be easy to find. The first amendment is in Section 4 of the bill, so I'm scrolling there now. And this has to do with the orders for non-hospitalization and the process for ordering the actual order for the non-hospitalization. The earlier draft had language that the commissioner is, if the commissioner determines that treatment at a forensic facility is appropriate, the court shall order it. This new language has sort of an interim step that says the court also has to make a finding. It's not just if the commissioner feels it's appropriate, it's if the court also feels it's appropriate. So you'll see the new language reads, if the commissioner determines that treatment at a forensic facility is appropriate and the court finds that treatment at a forensic facility is the least restrictive setting adequate to meet the person's needs, the court shall order the person to receive treatment for a period of 90 days. So it has that court determination that has been added there. The next change is the very end of the bill. I will scroll there. If you remember, the bill as introduced had a rulemaking section that required the Department of Mental Health and Dale to jointly go through a rulemaking process to address the criteria for admissions to a forensic facility. The amendment that you're looking at now that the administration was proposing was, instead of rulemaking, to have a memorandum of understanding between DMH and Dale as to the operations of the facility and the criteria for admission into the facility. So that is what you are seeing in Section 18. Just to go through the language, it says, on or before July 1, 2023, the Departments of Mental Health and of Dale shall jointly develop a memorandum of understanding for the purpose of determining appropriate admission criteria to a forensic facility. The MOU shall establish guidelines to ensure that an individual is served in the least restrictive setting necessary to meet the needs of the individual. An individual's treatment and programming needs dictate that the treatment or programming be provided at an intensive residential level. And an individual only receives treatment or programming within a forensic facility if the individual has demonstrated a significant risk of dangerousness, such as inflicting or attempting to inflict serious bodily injury, or on another, attempting suicide or serious self-injury, or committing an act that would constitute a sexual assault or lewd or lascivious conduct with a child, and there is reasonable probability that the conduct will be repeated if admission to a forensic facility is not ordered. Threatening to inflict serious bodily injury to the individual or on others, and there is reasonable probability that the conduct will occur if admission to a forensic facility is not ordered. Obtaining results on any applicable evidence-based violence risk assessment tools showing that the individual's behavior is deemed a significant risk to others. Or having a prior criminal history, including providing preference when all other criteria have been met to those defendants charged with felonies who have been held without bail pursuant to 7553 or 7553A of Title 13. And then in subsection B, we have language that pertaining to legislative input. So by October 1st of 2023, the departments shall present the MOU to and solicit input from the Joint Fiscal Committee and the Joint Legislative Justice Oversight Committee. The department shall execute the memorandum of understanding after considering each committee's input, but not later than December 1st of this year. And then there's just a conforming change in the effective dates to reflect the fact that the title of section 18 has changed. And that's it for amendment.
In the memorandum of understanding, you still have the new section that we just went over on page 7 regarding the court okay on admissions, correct?
Page 7, that was the language in section 4.
Yeah.
Yep.
That's still, I mean, the court still has a say over who gets placed in the forensic facility. Am I correct?
Yes, this gives the court more authority to weigh in on that decision.
And the memorandum of understanding doesn't change that.
It does not. We're looking at two amendments. One is on page 7 and the other one is at the end of the bill in section 18. We're talking about how they fit together. No, so the memorandum of understanding doesn't change the court's authority to have to make a finding that treatment at a forensic facility is the least restrictive setting adequate to meet the person's needs. Regardless of what's in the MOU, the court would still have to make that finding for somebody to be on an ONH at the facility.
I personally would be uncomfortable with the MOU being the determining factor for admissions without that provision that allows the court to review at least. I don't know how they can.
Could you repeat your concern one more time? I didn't fully catch it.
I would be concerned about allowing admissions to be determined by a memorandum of understanding without the court being involved with individual signing off on individuals who would be placed in the forensic facility. And there, the court would be looking at making sure that the least restrictive setting adequate to meet the person's needs. So I think I can live with the memorandum of understanding as long as that language is there on page 7 and 2 that allows that court finding. Usually we don't allow, well, I don't know what we do. I shouldn't say that. But in this case, with a memorandum of understanding, determining who is eligible to get into the facility, without that, you'd have no review as far as I can see. Did that help or muddy it further?
I hear where you're coming from now. Thank you.
Peggy, we're gonna need to schedule time the week after town meeting, probably a couple of hours to hear from Matt Valerio, Bor Yang, and the Department of both Dale and Mental Health on the bill.
Right now, we have 9 to 10:30 on Wednesday. Is that enough
Okay,
time?
I hope that'll be enough, but this is an important bill. Hopefully Katie can be with us at that time.
Yes, we already have it on our calendar.
Why don't you try to book it till 11,
Oh, yeah, we can, okay, yeah, we can do that.
just in case we need a couple of hours.
Yeah.
I'd also like to get the competency bill. That's, I think, not S92. At least if Senator Baruch is able to get us a dispensation from crossover for that.
For which, Dick, 92?
Yeah, the competency bill.
I could do that Friday morning.
Yeah.
Well, we haven't asked any favors yet, so.
No. But we can wait for them to ask.
Good idea.
This is a public broadcast, so they probably will know. But at any rate, both bills are, I think, important in getting us on the right track in terms of our mental health system. But I don't want to rush the committee through S89 without proper discussion.
And I think it's great. We're going to be hopefully hearing from Bor Yang in the Defender General's office. I wouldn't want to, in our good faith haste to, work on the mental health crisis. I also don't want to, let slip the folks who are actually going into these facilities, and I just want to make sure that they're also adequately represented in this discussion.
Mm-hmm. No, we need to. I think we're running out of Katie's time at 10:30. We needed to shift anyway. So Peggy, can you do your best? Are there other people we should hear from on this bill?
Dick, I'm not sure if Jack McCullough might make sense.
We heard from him yesterday.
Okay, I wasn't here.
But certainly he's invited to join us again. As we mark up the bill. And his basic testimony was that he wasn't sure it's needed, and that if you build it, they'll come. Okay. Katie, thank you very much. I know you got to get to health and welfare.
Thank you.
I know it's a long trip down the hall.
It sure is. Thank you.
Thank you. Ben, do you want to come back and join us as we switch to S16?
With pleasure.
Wow. Okay. want to first start by thanking Senator Norris and Senator Hashim for setting up those witnesses. It was extremely helpful this morning, quite frankly. And I appreciate the testimony. I'm not sure what to do with the bill, but and I know that Senator Norris had to give up tapping a tree in Franklin today. We appreciate that sacrifice. Ben, what do you know about New York?
So I qualify this. That
In terms, excuse me, what do you know about New York in terms of the their exemptions?
Yeah, I still need to do a little bit more review on the exemptions themselves. What I do know from my cursory review of the mandated reporter legislation is that clergy is not explicitly mentioned as a mandated reporter. Christian Science practitioners are, but there is language that anybody that could be responsible for a child, and that's cross-referenced with the meaning that's in the Family Act of New York, and I haven't had a chance to review that fully yet. So it's possible that clergy could be swept in under that meaning. But again, I need to do a little bit more of a deep dive to really get at the answer to that.
I've got a question.
Yep.
You know, maybe Ben, you could help me out on this, but you know, we heard from, you know, 3 priests from one religion, and yeah, I just want to clarify that this is not something that is targeting one religion in any way. Rather, it's a very broad removal of an exemption for mandated reporters. Is that accurate?
Well, the way I would phrase it is just sort of looking at the context of the statute itself, right? So, you know, in Title 33, in 4913, there is a list of enumerated individuals that must report child abuse and neglect or reasonable suspicion thereof. Clergy is listed, but listed amongst many others, including healthcare providers, camp counselors, school administrators, teachers, librarians. So, you know, I don't want to assign a specific intent behind a law, because it's not really my job to do that. But, you know, if you look at it holistically, it just creates a list of, and a comprehensive list of individuals that must report suspicions of child abuse and neglect. It seems like that is what the law is trying to achieve, but I don't want to assign a specific intent behind it. I think it's ultimately up to the public policy considerations of the committee to really determine what the law is trying to achieve and how best to achieve it. So I know that might be a little unsatisfactory, but I would just suggest for the committee to look at the statute holistically and who's listed as a mandated reporter and what the purpose of those mandated reports are to address, which is child abuse and neglect.
Would it be helpful for this bill to draft a findings or intent section, and that would fall on us, I would imagine?
Excuse me. Well, I would draft it, and then it could be debated by the committee. That could assist in helping assign a purpose to what the legislation is trying to achieve. It may not necessarily be the end all be all if a court were to later interpret the statute, but it would definitely assist in communicating the intent at least.
If I'm looking at current law correctly, Um, the exemption is almost too broad in my, based upon the testimony this morning, both from the bishop, Monsignor, as well as the other two witnesses. I think clearly that the exemption that would be required to be kept confidential by religious law, doctrine, or tenet, but intended by the communicant to be an act of contrition or a matter of conscience. I don't know why we exempt that, because that may be going beyond the confessional.
That's possible, but all four of these need to be read together because it's an and. So they would all need to be present for the exemption to apply. So as I previously said, I'm not a religious expert. I don't know the situations in which you would have all four. I do know that based on previous testimony, confession seems to be sort of the fallback example. But we could the committee could remove a prong or two to adjust the scope of the exemption.
Well, it would make clear that there's a certain time anyway.
Senator Bohofsky has her hand up.
I am certainly happy to narrow this how we need to narrow it. But one of the things I'm wondering is why we aren't including the other categories for mandated reporting, like vulnerable adults, and why it is only pertaining to children.
Vulnerable adults are handled in another provision of law. And there's actually a bill H-171 that is currently being debated concerning vulnerable adults at the moment.
Got it. Thank you.
I would, I'm going to suggest something unusual for me, since it's my bill. I'd like time to research what other states have done, and if in fact the other states are just silent on the issue. Some states like Massachusetts and Vermont provide an exemption. Other states are silent. And I think before we delve too much further here, there's some constitutional issues. I did get an email from a constituent who is both a minister in a Protestant denomination as well as a lawyer, which put him in a position at times to prosecute members of his own faith for the church because of behaviors. And he had some interesting takes on this bill, and thought that overall, while he would prefer to see the exemptions lifted, probably unconstitutional. So I'm wondering if the committee would be amenable to letting myself and Ben work on this over the summer and come back next year and look at how we should deal with the exemptions and if there's a better way. I'd like to understand what other states have done and what happened.
Makes sense to me.
I was under the impression that the other states had no exemption and that priests and others were required to report. Nick, clearly based upon the testimony this morning, that may not be the case.
If I might.
Yeah.
I appreciate that, Senator Sears, and I support that. As you well know, I would like a little more clarification on the actual definitions of the four exemptions also. But having said that, I'm not approaching this from a religious aspect, so on and so forth. And your last words was clearly what I was leaning toward. I'd like to try to keep religion out of beliefs or disbeliefs, whatever else, because unfortunately, I think that's the road we don't want to go down to. I think I heard a very smart secretary the other day say, neither shall state and religion ever meet within government. But my concern is the First Amendment, which, Congress shall make no laws respecting the establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. So I would almost think the press would be on our side of this here, but I'm not going to speak on their behalf. But I do like the idea of slowing it down a little bit, taking a more closer look at it. I think we all are very concerned about any assault on children, be it sexual or otherwise, because I have a family also here. But this really isn't about. It seems like we're trying to put it under the guise of protecting our children, but I lean more toward this is about the First Amendment rights here versus one religion versus the way this is going here. But I do appreciate slowing it down a little bit. Let's take a little deeper look. As you said before, sometimes the simple bills, the 2 pages aren't quite as simple as we think they are. And I want to do what's right here.
Yeah, I agree. I have to admit, one of the people I kept thinking about was Whitey Bulger. What do you suppose he confessed to at times? And, so God only knows. And, but I'd like to better understand what the other states have done. It seemed pretty simple. I thought they had some states had exemptions, others had no exemption, and the priest or other religious leader was required to report, but that's not the case.
And Senator Sears, to that point, I mean, it is kind of a mixed bag across the country. With just how the statutes are written. Some enumerate like we do, some keep it pretty general that just say a person in position of trust or responsible guardian, and then there are specific exemptions as well. But I think that the committee's heard through testimony that there are different interpretations of the import of those laws and whether or not they can be construed as ones that exempt clergy or not. And so while they do exist throughout the country, how you may classify them as affecting clergy or not, I think is probably a point of debate that the witnesses have raised.
Can you ask NCSL to look into this for us?
I can reach out to them, yes. And one final point, Senator Hashim, you had mentioned sort of like the purpose, right? And in Title 33, Section 4911, there is a purpose section for this subchapter that talks about reporting abuse of children. And the first statement is to protect children whose health and welfare may be adversely affected through abuse or neglect. So that is a stated purpose of the subchapter that that the bill would fall under. So just as context for the committee.
Thank
you. Excuse me.
Well, simple little bill, right? And
just a little 2-pager,
Back when we started looking at this, it got complicated. Anyhow, it's so. I want everybody to enjoy their town meeting break and get ready for the excitement of the week after town meeting, when we'll be in a real rush to get some bills out. But I think we've done some good work already, and we'll continue that when we get back. And thank you all very much. And I'll see you. Hopefully, I'll be in person when we get back.
I hope you have a restful town meeting week, Senator
Thank
Sears.
you,
and
you
that
too.
you're 100% back in action when we get back.
That's the plan. Thank you.